Hi guys, it's Luke here, and this is a lecture from Mewburn Ellis, another guest lecturer in this series, and they're here to talk about patents. Mewburn Ellis is one of the largest IP firms in the UK, which deal with patents, trademarks, designs, and other things like copyrights as well. They've got 5 interconnected offices in the UK and Germany, and they are part of the top tier of the UK patent firms. So what is IP? IP is intellectual property, which refers to creation of the mind. Obviously, these include inventions, library and artistic work, symbols, names, images, and design, and used in commerce. They take many forms. There's patents, which are for technical features and innovations. There's trademarks, which are brand names and logos. There's registered designs, which is appearance, and then there's copyright, which is used for literacy, dramatic, musical, and artistic pieces of work. And these are immediately in effect for musical if they have it, essentially. So an example, a registered trademark is Apple and its logo. They're registered trademarks, and the company Apple holds thousands of registered trademarks, such as the screen and many other things. And Apple has patents on technical designs and thousands of registered designs for its products as well, as in the screen, the touchpad, the camera, just everything about Apple, pretty much. So let's move on to patents. Patents are property. They have monetary value and investors like to see them when they're trying to invest. They are a monopolistic right, meaning that they detail what cannot be done by others. Territorial, which means that in other countries they won't be the same. And anything technical can be patented. Products, apparatus, methods and uses, and also, that's all of them. They need to be novel, inventive, and capable of industrial application, and this sentence is very important. So the legal bit. A monopoly right that lasts up to 20 years is what is included in the patent, and on expiry the invention is part of the public domain, which means it's usable for everybody. Disclosure of your invention to the public may lead to having an invalid patentability, but it's also country specific. So a paper including a patent, the title would not give the game away so that someone can't try and copy their work in a quicker time. But it does include in the article a description of the invention, definition of the monopoly, the name of the applicant and the name of the inventors, which also includes some figures, some claims, and the claims will be as broad as possible so that an inventor can't work around those claims. So for example, we've got the claims for a pencil here. And this is what the claim was. A writing implement comprising of a core of pigmented material, which could lead to anything from lead to graphite or whatever. And this was important because if someone said lead, then someone may be able to make a pen of something else, or pencil of something else. For leaving a deposit of the pigmented material on the surface, instead of drawing, this is making sure that they're covered on all grounds. And a casing surrounding the core, which means the casing could be anything. Rather than saying like a wooden casing, it means that it could be anything like a metal casing or a plastic casing or whatever. And this is broad enough, and the green words are the broad words that do help towards a broader pattern. So we're going to have a look at the novelty. You need to see if it is new. You need to compare it to the prior art from anywhere. So you can look at documents, posters, lectures, non-confidential discussions from any country, just everything. You need to make sure that it's not been done already. All features are in one document, have to be there. So to obtain a patent in Europe, the invention must not have been made available to the public in any way, at any time, at any place. Meaning that if it's been disclosed to some of the public at a different time and people scream and shout about it and people know about it, then you could have an invalid patent in the EU. The inventive step. So a person who is skilled in the art is an imaginary, but an idea must not be obvious to a nerd, essentially. So a person who is skilled in the art is pretty much an expert, but they are imaginary. They're as if they know every step of everything. But if you make something that's surprising to someone who knows everything, then that's essentially an inventive step. And this person reads everything, knows everything. That's what I mean by a person who's skilled in the art. So an invention is inventive if the result is surprising, as I mentioned. The problem is difficult to solve and has not been solved before, or combines teaching from different technical fields. So law says what is not an invention, which are discoveries, so such as theories and methods, aesthetic creations, schemes or rules, and presentations. These are not inventions yet, but can be the start of inventions. There are some excluded patents, inventions contrary to ordre public or morality. So this is whether it is probable that the public in general would regard the invention as so abhorrent, which is just wrong, essentially, that the grant of the patent rights would be inconceivable. For example, anti-personnel mines, like landmines. Cloning humans is also something that's not something you expect, because I think it needs part of the a uterus, something, I don't know, I'm not sure. Modifying the germline genetic identity of human beings, use of human embryos, there's the embryo, not uterus, and genetically modified mouse designed to develop cancer. So some of these things that aren't moral, essentially. However, when you're looking at methods of medical treatment by surgery or therapy or diagnosis, medical practitioners should be free to go out about their business without making any patent infringement. So that's saying that they can use any technique, any method, or any apparatus that has a patent on it in order to save your life, obviously, without having to worry about getting told off for it. This includes minor surgery, therapy, cosmetic effects, and diagnostic effects on human or animal. So there's some examples here. Tooth whitening can't be patented as removal of plaque. Prevents dental disease. I think that should say can be patented. Contraception using alicyclic compounds can be patented due to prevention of pregnancy as not a general therapy. I think that should be can't. So I think it should be can, then can't. And improving yield in pig farming by administrating pesticides on pig skin can't be patented because it's a therapy on a pig. Never mind, I see. That can't be patented because it's medical. The two can't be patented because they're medical, so these two can't be patented because they're medical, whereas this one is not medical, so it can be patented. So compounds can be patented, or patent product, not the method. So even if a compound is known to a prior art, so you could patent the method to making it. An example here is Warner Lambert versus the generics company. He made a molecule called pregabalin, which was used for an antidepressant, which has a patent in force, and then pain relief, which had expired the patent. And generics wanted to manufacture using the pregabalin for pain relief, just not anxiety. So this has to be claimed to not be used for the patent usage, anxiety. Inventorship and ownership. By default, the inventor usually is the owner of the invention, but the employer owns the employer who owns the employee-generated IP is normally in a contract. So the employer owns the employee-generated IP. So essentially, this is the invention, which means the employee is normally the owner. Employer is normally the owner, and this is normally in the contract before signing up. This is the same for the university employees, but students are not employees of the university, and a separate agreement will have to be made between the uni and the student. Not identifying the owners or inventors could invalidate a patent. This needs to make sure that everybody knows who's in there, so that it's a completed document. And an employee inventor can get compensation if two conditions are satisfied. The patent is of outstanding benefit to the employer, which means they've generated a lot of money for it or saved a lot of money, and it is just that he or she should have been awarded compensation. There's also this issue with freedom to operate. So a patent is not a right to use your invention, but it's a right to prevent others from using it. So you may need to use something covered in someone else's claim, and therefore you'll need to use a license. For example, the bike. So the bike would use a wheel which has been patented, but the bike itself would be something else. So they need to get a license for the wheel, or try and buy the patent off them themselves in order to do that. A patent is like a house, essentially. So you live in the house, you take in a lodger potentially, i.e. your husband or wife or whatever, and then you can rent it out to other people, and then eventually you might sell it. And the live-in is essentially commercialising. The taking a lodger is licensing in your patent. Then there's an exclusivity license, and then you can sell the license. And that's pretty much everything on patents. Next up, we've got some business skills for chemists and some calculations.